All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Latiris Bates, I have verified in Smith County. We'll recall that case. Joshua Moyers, Joshua Lawrence Moyers. Sean Nunez, William Lee Ponder, Chase Harrison.
President, counsel.
Thank you, Mr. Grove. Terry Johnson.
Here.
Christopher Carroll.
Here.
Randa Boaz.
Counsel.
Thank you, Mr. Northcutt. Seth Atkins.
Here.
Carissa Coleman.
Here.
Jaden Hester. Jaden Hester is verified in custody in Smith County, had information that she pled to 10 years TDC Smith County yesterday. So we'll recall that case. Jeremiah Holmes. Anthony Murray.
She's coming.
Thank you, Mr. Schmidt. Stephen Richardson.
Here.
Robert Wheeler. Robert Dwayne Wheeler. Jonathan Daniel.
Here.
Anyone in the courtroom who expects to be on the docket, your name's not been called? All right, seeing no one, we need counsel that's ready. Mr. Wells.
Mr. Daniel, Judge.
Jonathan Daniel, CR 25-38. All right, Mr. Wells, Mr. Daniel is set for pretrial today.
Yes, Judge, we've worked this case out and I talked to Patty about a plea date. If it's acceptable to you, we said October 28th at 1:30.
October 28th at 1:30. Any objection from the state?
No, Your Honor. Thank you.
Is that a morning plea or an afternoon?
Afternoon, Judge.
Afternoon. All right, court sets Mr. Daniel then for plea before the court October 28th at 1:30. The Vanzant County Justice Center. Well, it's free to go. Mr. Northcutt. Randa Boaz, CR 22-352.
Your Honor,
Let her get up here so she can be a part of it. Sorry, Ms. Northcutt, go ahead.
I know this is an older case. However, I was just retained about a month ago. I've received discovery in this case. Me and Mr. Hartwell have been in constant communication regarding this matter. And I believe we're in agreement just to get it reset for 30 days in hopes that we can resolve this.
Any pretrial issues?
Not at this time.
Do you file any pretrial motions?
Not at this time.
All right, court, any objection from the state, court setting it for docket call in about 30 days?
No objection, Your Honor.
All right, the court finding that no pretrial motions having been filed, the court sets Ms. Boaz for docket call.
And Your Honor, just for the record, because of the age of this case, if Ms. Northcutt did need to file a late motion, state would not be opposed to that either, just as we're kind of getting our feet under us.
Noted. Ms. Northcutt, October 14th, October 16th.
Let me check my calendar, Your Honor. I'm sorry. October 14th, Your Honor.
All right, court sets Ms. Boaz then for docket call October 14th at 9 a.m. Once she signs her notice of appearance, she's free to go.
Thank you, Your Honor. May I be excused?
Yes, ma'am.
Thank you.
Chase Harrison, CR 25-131. All right, Mr. Griffith, Mr. Harrison is set for pretrial.
Yes, Your Honor, I've spoken with the state. There are discovery videos that are from 2019 that are being now put in a format to place on LGS so that we can view it through discovery. And we've come to an agreement that this could be passed till the October date, whichever the court wants.
Any update on discovery?
Yes, Your Honor, just due to the age of some of these videos, it's taking some time to make sure that they still work properly. So we would ask for an additional pretrial so that Mr. Griffith has time to review those, file any motions that he needs. But we are working on, I think we're pretty close to having everything in the proper format to be uploaded into LGS.
Mr. Griffith, October 14th or 16th.
Yes, the 16th would be great, Your Honor.
All right, court sets Mr. Harrison for an additional pretrial October 16th. That'll be at 9 a.m. Mr. Harrison, have you met with the pretrial release officer, Mr. West, and signed your conditions? No? Okay, that's Mr. West behind you. He's the court's pretrial release officer.
Yes, sir.
Once you sign your notice of appearance, you'll need to meet with him.
Yes, sir.
There'll be conditions that you'll have to comply with while you're on bail in this
Yes, sir.
case. All right, and the white notice stays with me, yellow goes with him.
Okay, thank you. Here you go.
Thank you.
You're welcome. Any other counsel ready? Mr. Hawkins, you ready? Christopher Carroll, CR 25-143 and 144. Mr. Carroll is set for pretrial. Mr. Hawkins, go ahead.
Your Honor, I'm actually asking for an extension of time. I filed a motion to compel discovery last night. My online access is being, I'm prevented from accessing it. Apparently there's an issue with the district attorney's office and I guess my employee and so my online portal access has been disabled. And so I filed a motion to compel and I'd like to have a hearing on that part sometime in the next, and I guess at the court's earliest convenience. But I'm not able to have any discovery in this case.
Dave.
Your Honor, we did receive that motion this morning. State would, I guess, ask that it be set over to contested for the court to hear any argument on it. In the meantime, if it's something that can be worked out, we'll get on that, but.
Are you trying to compel a reduction of a certain piece of discovery or all discovery?
All discovery. Haven't gotten anything, Judge. I've been offered to come to the district attorney's office and see the discovery, but my online access, I've never had it. It's always been available. I've never had it cut off. It's over, I think it's a retaliation issue. And so I'd like to have a hearing on it so we can get that resolved so that I can have discovery because it's not only affecting my client, this client, I've got other clients in this county that are affected the same way.
State.
Your Honor, I'm not entirely familiar with the entire situation. I know discovery is always available at our office. As far as the particulars as to why online access is not available, I'm just not familiar. I know Ms. Curry is. She's not here this morning, but with some time to communicate. Again, we received it this morning, so I haven't had time to get informed on the situation, Your Honor.
We're going to recall the case for this morning, later this morning. So stay here. I'll recall the case. Y'all be prepared. We got to have discovery given. I mean, that's statutory right. We're at pretrial. So we should already have discovery produced to the defense at some point. If there's an issue with that, then let's get it resolved this morning. So I'm going to recall your case and be prepared to tell me more about it.
Yes, Your Honor.
Mr. Schmidt, you ready?
Yes, sir.
Who are you ready on?
May I approach Judge with
I can understand you.
Can I approach?
Yes.
The rest, please.
All three. All right, Mr. Schmidt, who are you ready on?
Sean Nunez.
Sean David Nunez, CR 25-184. Mr. Nunez is set for arraignment.
That's correct, Judge. We received a copy of the indictment this morning. His name spelled correctly, understand the charges and the range of punishment. We waived formal reading of that indictment and entered a plea of not guilty, asked for a pretrial setting.
All right, the court finds Mr. Nunez having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Sets Mr. Nunez for pretrial hearing. Mr. Schmidt, October 28th.
Yes, sir.
Court sets Mr. Nunez for pretrial October 28th at 9 a.m.
Send me that email that you met with Mr. West. Pretrial. They have you sign conditions of pretrial. You'll probably need to do those. He needs to meet.
Mr. Nunez, come over here and meet with my officer and figure out if you're on conditions of pretrial release.
And Judge, the court called Robert Wheeler's name. He wasn't here. I'd like to recall that later in the docket. I just want to make a note of that before we move on.
You want me to go ahead and call Wheeler at this time?
Judge, if we could recall it, I'll briefly address it in a minute. But Carissa Coleman, we're ready on her.
Mrs. Coleman. Cause number CR 25-00035, State versus Carissa Bernice Coleman. Ms. Coleman is set for docket call today.
That's correct, Judge. Ms. Coleman's coming from Detroit to make her court appearances. We have not had an opportunity to meet in my office yet. We've got that arranged for this afternoon around lunchtime. So we're going to ask for an additional docket call setting.
Any objection from the state?
No objection, Your Honor. Thank you.
October 28th, Mr. Schmidt.
Yes, sir.
All right, court sets Ms. Coleman for docket call October 28th. And Mr. Schmidt, I'd like to set that for final docket call.
Yes, sir.
That'll be on a
I should be over there around 9:30. I'll make it. Later. Excuse me?
Mr. Holmes. Court calls cause number CR 24-141, State versus Jeremiah Garen Holmes. We're set for final docket call today.
Are we set for final, Judge? I was gonna ask that the court set us for a final docket call.
No, I believe we are set for final today.
Then we'll announce ready for trial.
All right, what was the offer that has been extended, if any, to Mr. Holmes?
If Your Honor will give me just one moment.
Do you know, Mr. Schmidt, off the top of your head?
Judge, it was a pin time offer. I believe it was 5 TDC, if I recall correctly. 4.
For TDC, Your Honor.
All right, and your client understands that the court may not allow him to accept that if it's offered at a later date.
Well, I did explain that to him, Judge. And since this is a final docket call and the court is not granting me an additional docket call, our only option is now it's ready for trial. And then at that point, request that the court entertain a plea if we reach that point.
All right, court finds that the state and defense have exhausted plea negotiations and no offer being accepted. The court hereby sets Mr. Holmes for jury selection. We'll begin that next week. Actually, let's do this. Let's go to October 6th. We'll set Mr. Holmes for jury selection beginning October 6th. And Mr. Holmes, on that date, when you come to court, you will not come to the courtroom. You'll be downstairs with a staff member and the pretrial release officer, and then you'll be given a new date if you're not reached for trial.
And we'll talk more about it, but it's just. That's all.
Let's go ahead and call Jaden Ray Hester, cause number CR 25121. Ms. Hester is set, for pretrial. As I've mentioned earlier, the information I have is that she accepted a 10 years TDC sentence out of Smith County yesterday, I believe.
Yes, sir.
The state wanting to have her bench warranted back.
Yes, Your Honor, I believe since she accepted a TDC, Smith might be a little bit hesitant sending her right now. If we could set it for maybe 2 months after she catches chain, I think we'll be able to wrap this up in one go if we want to set it out for a couple of months.
Well, and Judge, basically, I talked to Ms. Taberham, I believe yesterday, about seeking a bench warrant from Smith County before she catches a TDC chain. I think we have a resolution. It's simply a matter of getting her here, and doing the paperwork. That way, we're not pulling her out of TDC.
It's going to depend on how quickly TDC gets their, that Smith County gets their TDC ticket.
Yes, sir.
We can try, let's set it for September 30th and make an effort to get her to save our sheriff's office from having to travel to TDC to pick her up.
Yes, sir.
So we'll set it for September 30th and Ms. Taberham, if we do that bench warrant today, maybe we can notify Smith County. Maybe they'll hold off on getting a ticket if they know we're going to take custody. So it'll be September 30th at 9 a.m. for pretrial. Yes, 1:30 actually, yes. Good catch on that.
And Judge, I would ask that, I believe she may still be on bond in our case. If the court would find her bond insufficient, revoke that.
All right, the court grants the defense's oral motion to find bail to be insufficient in this case. Court grants that. We'll issue an order. Mr. Horton, are you ready, sir? Terry Lorenzo Johnson, CR 23184. No. I'll just do it. Take too long. Don't thing in my. Tracking down the plea papers, just. I'll tell you what, go ahead and have a seat, Mr. Johnson. It's going to take a moment. Big work to get done. I'll recall your case. Just sorry. Sir. All right, court's going to stand in recess for a few moments. Yes. Mr. Carroll. This is cause number CR 25-143, CR 25-144. State versus Christopher Roy Carroll set for pretrial. We were going to reconvene to discuss the lack of discovery issue. And it's my understanding, Mr. Hawkins, you announced to the bench that you and the state that you'll have resolved the issue and that you now have discovery for your client.
It'll be accessible today. They've informed me, Your Honor, so I will have it at some point today, yes.
Okay. Court will reset Mr. Carroll's case for pretrial. Let's do Mr. Hawkins. I've got the 14th or the 16th.
Either one's fine, Judge.
Either one.
Yes, Your Honor.
All right, we'll keep it on Tuesday. We'll do October 14th. That'll be at 9 a.m. Once he signs his notice of appearance, it's free to go.
Thank you, Your Honor.
Mr. Johnson, come on up, sir. I've got your paperwork now. Yes, thank you, Mr. Hawkins. Thank you, Judge.
Thanks, Max. Take care.
Sorry about that, Mr. Johnson. All right, this is cause number CR 23-184, State of Texas versus Terry Lorenzo Johnson. Mr. Johnson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Sorry, I couldn't hear you.
Yes, sir.
All right, just make sure you speak up loudly and clearly. You can put your hand down. I've got to be able to hear you. You can put your hand down. Put your hand down. You can put your hand down. I've got to be able to hear you, and so does my court reporter, because she's going to type down everything that's said in court today, okay? All right. If you don't understand a question, just tell me that you don't understand. All right, your name is Terry Lorenzo Johnson, is that correct?
Yes, sir.
And Mr. Johnson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Ron Harden. Are you pleased with Mr. Harden and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the plea paperwork that you've read over and signed today?
No, sir.
Mr. Harden, do you believe Mr. Johnson to be competent to enter into a plea? And if so, that he is doing this plea intentionally, knowingly, and voluntarily?
I do, Your Honor.
And Mr. Harden, did you also explain to your client the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
All right, Mr. Johnson, I see that you were originally indicted with the third-degree felony offense of theft of cattle, horse, or livestock. I see that the range of punishment for that is a third-degree felony, which is not less than 2 years in prison and not more than 10 years in prison, and also a possible fine not to exceed $10,000. I see the plea agreement in this case is that you would be pleading guilty to that offense in exchange for the state's recommendation that a finding of guilt be deferred. That means that even though you'd be pleading guilty, you would not be found guilty here today. The court would defer a finding of guilt and would place you on community supervision for 2 years. And as part of that community supervision, we'd have restitution in the amount of $1,350.75, which is reflected that it has been paid in full to the victim of this cause. In addition, you would be responsible for court costs of $290, reimbursement fees of $70. Mr. Johnson, is that your understanding of the plea agreement?
Yes, sir.
Understanding the plea agreement and the range of punishment, how do you plead to that offense?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Yes.
Yes, sir.
All right. And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Harden, any objection to the evidence being admitted?
No, Your Honor.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that victims in the case are in agreement with the plea agreement.
And just for clarification, the restitution has been paid or it's going to be paid?
Has been paid already in full, Your Honor.
Thank you, Mr. Harden. All right, anything further from the defense?
Nothing further to the rest of the club.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement and recommendation. Court hereby defers a finding of guilt for the defendant Terry Lorenzo Johnson on third-degree felony offense theft of cattle. Court places Mr. Johnson on 2 years deferred community supervision, orders him to pay restitution, and finds that he has already paid restitution in the amount of $1,350.75 to the named victim. Court also orders court costs in the amount of $290 and reimbursement fees of $70. Mr. Johnson, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward. Sergeant Martinez is going to take your fingerprint. After that, you'll meet with the probation officers and you'll get more information. Yes. Anything further, Mr. Harden?
Yes, Mr. President.
Thank you, sir.
May I be excused?
Yes, sir. Good to see you. All right, for the record, court call CR 25-180, State of Texas versus Laterios Untre Bates, set for arraignment. Mr. Bates is verified in custody in Smith County Jail. Court finds that there is a 1716, said 1716 on record. All right, court will grant the surrender of principal and execute that warrant. And we'll reset Mr. Bates for arraignment October 28th. For arraignment and status on Smith County custody. This is cause number CR 22-336, State of Texas versus Anthony Wayne Murray. And Mr. Murray is set for pretrial or possible plea today. It's come to the court's attention that the state has filed a motion to dismiss Mr. Murray's cause, indicating that he is pled guilty in a federal case and is currently under federal supervision. Assuming Mr. Schmidt, you and Mr. Murray have no objection.
No objections, yes.
There being no objection, the court grants the state's motion to dismiss. Court has signed that order. Mr. Murray, you're free to go.
Thank you. Judge, may I
You want a
have-
copy for your record?
Yes, please.
Abraham will get you one.
Wait, no.
All right, court's going to stand in recess for a few moments, probably 15 to 20 minutes. So it's 9:45. You can check back in at 10 o'clock in court. Mr. Atkins, come on up. Second page, on the record, cause number CR 22-368, State of Texas versus Seth Edward Atkins. Mr. Schmidt, I believe that Mr. Atkins was set for a plea today on his motion to adjudicate. Any announcements?
Yeah, Judge, and I believe I set it for plea, and I discussed the potential outcomes with the state yesterday evening. I met with Mr. Atkins this morning, relayed that to him. He's just now out on bond. We're going to ask for a reset to the contested docket in October, and that'll give he and I an opportunity to meet in my office and go through his options.
Any objections from the state?
No objection, Your Honor.
All right, court sets Mr. Atkins then for the evidentiary contested docket on Thursday, October 30th. That'll be at 9 a.m. All right, Mr. Richardson, come on up. This is cause number CR 25-12 and 2024-219, State versus Stephen Ray Richardson. Mr. Schmidt, I believe that you filed a motion to withdraw as counsel in both of these causes. Is that correct?
That's correct, Judge. Mr. Richardson's been on the trial docket for a bit, and it's gotten to the point in an effort to resolve Mr. Richardson's case that we've had multiple opportunities to discuss his legal rights and his options. For various reasons, we have failed to communicate effectively to the point where Mr. Richardson, I believe, no longer trust that I'm acting in his best interest. For that reason, I've filed a motion to withdraw to allow the court to assess that situation to determine whether or not Mr. Richardson would be better served with new counsel.
Mr. Richardson, if you'll raise your right hand, I'm going to place you under oath. I'm going to swear you in for a limited purpose of discussing the issues surrounding the motion to withdraw as counsel. Mr. Richardson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, let me begin by asking you, Mr. Richardson, has your financial circumstances changed wherein you could go and hire your own attorney that you choose?
No, sir.
Okay, so you can't hire an attorney and you've asked the court to appoint you one, and the court has appointed Mr. Schmidt to represent you. And I've heard what Mr. Schmidt has said. What do you say?
The same, like,
I'll tell you what, why don't y'all come on up here? Mr. Richardson, go ahead and just tell me, what issues are there with Mr. Schmidt? Why you want him to withdraw as your attorney?
I don't understand everything, to be honest with you.
Okay, and like, can you tell me some things that you don't understand?
I don't understand how it's even making it to this far. Like, the evidence, the police report, 1 minute, I just don't understand. I just don't understand everything. Like, he seems like a good person. It's just, I don't understand everything.
Okay,
I just,
well, let me say something. Do you understand the process and how it works? Do you understand how the criminal justice process works in court?
some of it, some of it not.
Okay,
To be
tell
honest.
me what you do understand, so I'll kind of know where we're starting.
Well, I just don't understand how someone can say you did something you didn't do.
Okay, that's
I
fair.
I don't understand how a thief itself can say you broke into a house that you didn't do, and y'all can put a thief on a witness stand that knows she broke into the Walmart a few months back. I
Okay,
don't understand how that's possible.
okay.
I don't understand. I don't want to go to trial, but no innocent people take plea deals every day, and people that go to trial innocent people go to trial and they lose. And then they go to prison. I do understand that.
Okay.
I don't know.
Okay.
And I may done said too much, like I don't know what I'm doing,
Yeah,
to be honest.
you haven't said too much. I just wanted you to tell me what it is you understand and what you don't understand, so I can maybe help you fill in the gaps and help make sense of something. So, what you said earlier about you don't understand how someone can make a statement about you and we go to court about that. But do you understand that the criminal justice system is a system? It's a way of addressing accusations or allegations or things that people say. And it's a place, a courtroom, and the law that's used in the court is a place for those accusations or those allegations to be tested. And the testing of those is trying to determine, are they truthful? Are they untruthful? And you do that by way of evidence. And so if someone has made a statement against you, they make an accusation, an allegation, they said you did something, then the way that our criminal justice system is set up is the person that's making the accusations has to prove that. And they have to prove it to either a judge, like myself, or they have to prove it to a jury, which is what this jury box is for 12 people to hear what the accusation is and to determine if the evidence that supports that proves it to those people beyond a reasonable doubt, which is a really high burden. Okay. So in order for who is the accuser in this case? Well, it might be someone that the police have interviewed that gave a statement in a police report. But when it comes to legal accusations, it's going to be the prosecution. That's going to be these attorneys over here, and they're making a legal accusation. All right, that is supported by a factual accusation made by a witness or a homeowner or whoever it is, and it's their job to come in and lay out all of the evidence and to try to convince either myself or the jury that what is being said about you is true. Okay. Now, Mr. Schmidt's role in that is to help make sure that you have legal counsel, legal representation as your attorney to understand what your rights are and to put on a defense and to make sure that the prosecutors, also known as the state, to make sure that these people are doing their job according to the law. All right. So that's his job. He can't make them dismiss the case. He can't make them do anything. All he can do is advise you as to what your rights are and argue on your behalf and point out maybe inconsistencies with the evidence or weaknesses with the evidence and try to argue to a judge or to a jury that the evidence is not as strong as they say it is. But at the end of the day, there's going to have to be a decision about whether or not the accusation or the allegation is true. And that's going to be, either a finding of guilty or a finding of not guilty. Now, that's what's going to happen in the trial. All right. And I think you understand that because you said innocent people take a plea all the time, and in order to avoid going to prison, or they go to trial and they're found guilty and they still go to prison. All right. I understand that. But in what we're dealing with today is Mr. Schmidt, as part of the system, has been appointed to represent you as your attorney because he has legal knowledge, he has legal training and expertise in this very fact issue that we're talking about.
It's not just him, like I hear all kinds of stories. I hear that the house was supposed to be native, but it's supposed to be food well, it's supposed to, I stole this. I was on a scooter moped, like it just don't add up.
I understand. And what I'm telling you is what you need to understand is that he doesn't control what is said about you. They don't control what is said about you. Whatever accusations are being made, they're going to review it and decide whether or not they think there's enough evidence to present it to a grand jury. And they did that. And the grand jury found enough evidence to believe that you committed a crime and they indicted you. And now the indictment is in this court and the decision has been made to continue the prosecution. And so they're going to ask the court to either have you accept a plea agreement or they're going to ask the court to have you have a trial. And you get to make that decision on whether or not you accept a plea agreement or you have a trial. If you're saying that you're not guilty and you're innocent of it, then you don't accept a plea agreement and you go to trial. And in a part of the trial, that's where your attorney, Mr. Schmidt, is your advocate. That's where he works for you, and he helps the jury understand the evidence. He helps argue what the evidence is, what the evidence isn't. He is a defender as to what evidence is presented to the court and presented to the jury. So what you and I are talking about today, and what I want to make sure that you understand, is it's not about whether or not, I don't know anything about the facts of your case, Mr. Richardson. I know zero about the facts of your case.
And I'm sorry.
No.
I wasn't trying to confuse that, but I'd like to see if we just take a plea deal, just get this. Like, and I just get confused and I get overwhelmed. I'm sorry, like I am a little bit slower, like I understand some things, but I don't, like I do research, so YouTube, and I might get reading to a lot of things.
It's okay. Don't be sorry. It's okay. What we're talking about today is I just want to make sure that you understand the different components, the different parts of the criminal justice system. The part that I play, the role that I play, the role that the prosecutors play, the role that your defense attorney plays. And the only thing that we're talking about today is your relationship with your defense attorney, Mr. Schmidt. He's filed a motion to withdraw because he has concerns as to whether or not you believe that he is actually working in your best interest and trying to give you a defense against the things that are being talked about and that you're being accused of. And so Mr. Schmidt said earlier that he filed the motion because maybe you had expressed to him that you didn't feel like he had your best interest, or that he was trying his very best to represent you in this matter. So what I want you to understand is that Mr. Schmidt, all he can do is be reactive to the evidence and the information that's coming into the case and try to defend you by evaluating that evidence and deciding whether that evidence should come into court or not come into court. And then part of that is also to advise you on whether or not it's in your best interest to accept a plea agreement or your best interest to have a trial. But you get to make that decision. He doesn't make any of those decisions for you, whether you have a plea agreement or you don't. But what he cannot do, what he cannot do, and he won't do, is allow you to plead guilty to something that you would say, Judge, I'm not guilty of. And if that's a situation for you, then the only next step is, if the state wants to continue their prosecution, is that we go to a trial. And at that trial, that's where the evidence is offered, that's where it is tested, and that's where a decision is made as to whether or not the evidence proves that you committed the offense or it doesn't prove that you committed the offense. But he cannot allow you to plead guilty just to take a plea agreement. He can't do that.
I thought no contest. That's where I was doing no contest. I didn't say not yes or no. And I thought, under my understanding, no contest was not pleading guilty, or that. That's the way I was told, no contest, and that's the way they offered me 3 years, no contest. And probation, I was gonna drop to harassment charges. Because, I was forced out of my camper at the mountains over there. And I admit, like, no, okay. But
Well, let's talk. Let me say something.
I'm sorry.
It's okay. It's okay. I want you to listen for just a second, okay? Do you understand what the difference between no contest and innocence is? Do you understand the difference between a no contest and an innocent plea? Okay, so all three of those things are different. A guilty plea, a not guilty plea, and a no contest plea. Those are different, okay? So a guilty plea is you're admitting guilt. You're accepting legal responsibility and saying, I understand what's being said about me, what I'm being accused of, and I am legally responsible for that crime, and I accept it. All right, that's pleading guilty. All right, pleading not guilty can mean you understand what you're being accused of. You're not going to admit guilt to it, and you're going to require them to prove the case. That's their burden. They have to do it. You don't have to prove yourself not guilty. They have to prove yourself guilty. Okay? And then you have no contest. No contest means that you understand what you're being accused of and you're not admitting guilt to it. That means you're not going to defend yourself against the accusations. Innocent is different. Innocent means I'm not guilty of the offense. I'm not admitting guilty. I'm not admitting I'm guilty, and I'm contesting. I'm contesting everything. Innocence means different. It is completely different than meaning no contest. You understand that? So you can't come in and say, I want to take a no contest plea and then tell Mr. Schmidt that you're innocent. You can't do that because those are not the same thing. Innocent means you have no guilt whatsoever. You have no responsibility for the crime at all. No contest means that, yeah, you could have some legal guilt. You could have some responsibility for the crime, but you're just not going to contest their evidence. You're going to let them put their evidence in, and it's going to have the same effect. A no contest plea is going to have the same legal effect as pleading guilty.
I'm innocent.
Okay, so if you're innocent, then that's what I was saying before. Mr. Schmidt cannot allow you to take a plea agreement. Because during that plea agreement, Mr. Richardson, I'm going to ask you, how are you pleading to this? And if you say I'm pleading no contest, then I have to tell you that if I hear the evidence and you're not defending it, and there's enough evidence for the court to believe that you've committed the offense, then you're going to be found legally responsible for the crime. You're going to be found legally guilty. So a no contest plea is not the same as pleading innocent. If you're pleading innocent and the case continues, then the only next step is to have a trial and let a judge or a jury determine whether or not their evidence proves you legally guilty of the crime. And that's the opportunity that you have with your attorney to contest the evidence, to talk to the witnesses, to cross-examine them, and to try to point out issues in their testimony or issues with the evidence that's offered. So there's a big difference between pleading no contest and saying that you're innocent. And that's what we have to make sure that you understand.
Sorry.
Well, you don't have to be sorry. It's okay. There's misunderstandings all the time. So we're trying to be really careful in here because we want to make sure that you understand what your legal rights are. And so today, Mr. Schmidt has filed a motion to withdraw, I think at your request. Do you feel like Mr. Schmidt is giving you adequate legal representation, meaning that he's explaining to you how the system works, how trials work, how plea agreements work, how the law works?
I'm just around with all this. And I know all the witness. Everything.
You know the what?
I know the witness, like I hung out with him. It's just went to drama.
I understand. And you understand those are factual issues. Okay. Those are factual issues. There's a difference between factual and legal. Okay. So the facts are that's what's you're being accused of. That's what people are saying you did. Okay. Those are the facts. And then the law gets applied to those facts. And that's how we address legal issues. That's how these accusations get resolved and either accountabilities had or accountabilities not had based on whether or not the evidence is believable beyond a reasonable doubt that you committed an offense. But Mr. Schmidt doesn't control that. All he can do is react to the evidence that's being offered and tell you this is what his advice is on how you defend yourself.
Sorry.
So do you have any other questions about things that you don't understand? I mean, we're happy to talk about it today.
I just, what if the people don't show up for trial?
I'm sorry, say that a little bit louder.
People don't show up for trial, we go to trial.
People that don't show up for trial.
Yeah, because
Are you talking about defendants that don't show up for
Yeah.
trial or witnesses that don't
the
show up?
witness that they don't show up.
Well, if a witness doesn't show up, then either one side or the other can issue subpoenas and they can go and find them and make them come. Whether they want to be here or not, can force them to come. And they have to give their testimony. And then, so that's what happens. Or one side or the other can decide, well, we don't want them to come, and so we're not gonna make them come, and if they don't come and give testimony, then that evidence is not received by the court or by the jury.
I hope they do. 'Cause I want to get down to the bottom of it if I had to go to trial.
Well, what I'm hearing today, Mr. Richardson, is that the state has an accusation against you, and you're saying that you're innocent of it, and the only way that that's gonna get resolved is with a trial. So you say, if I have to have a trial, well, it sounds like to me, you have to have a trial, otherwise it's not gonna get resolved, and we have to get a resolution to the accusation.
I just don't want to go to prison, something I did.
I understand. Well, then in that case, if you're maintaining that you were innocent of the charge, then you have to decide, are you going to hire your own attorney? If you can't, the court's appointed you one. I've appointed you Mr. Schmidt. Are you going to be able to work with Mr. Schmidt and follow his advice, follow his guidance, and then make a decision? You get to make a decision on how you want the case to be tried and those things, but you have to work with your attorney in doing that. And you have to listen to what his advice is, because he's the one with the legal knowledge and the legal skill and the legal experience to help put you in the best position possible to have a defense in the case. You understand that?
Yes, sir.
Okay. And so do you still want Mr. Schmidt to withdraw and not be your attorney? No? And so, what would you tell, the court today about Mr. Schmidt and you wanting him to be your attorney? Like, how do you think that you will be able to continue to work with Mr. Schmidt or make it easy to work with Mr. Schmidt?
That he's a pretty good person. It is, I just don't think he understands me as well, but it's just the way I was grown up. I don't speak proper.
Are you in a position to be able to tell him when you don't understand something?
I don't understand a lot of things. I'm sorry. I tend to wonder off, tell the stories, trying to get to the point. That's my problem.
And is that something that you're gonna be able to address so that you can give Mr. Schmidt the best version of you possible? You understand, Mr. Richardson, during this time of your life, you and Mr. Schmidt, you're not gonna know each other forever. You haven't known each other forever. He's not gonna know who you are. All he can do is learn as much about you as possible for this period that he's your attorney. Get all the evidence in the case and say, this is how I think you should best present your defense. And there has to be a working relationship. It's not like a family relationship to where he's known you since you were a child. It's a working relationship. That means that you have to tell him things and he's going to listen. But then when he tells you things, you're going to have to listen. And then you're going to have to make some kind of agreement in between you on how the case is going to be presented. Can you do that?
Yes, sir.
And can you understand that he doesn't have all of this back knowledge on you? He doesn't understand all of these things, but you understand that he doesn't necessarily need to understand all of those things to give you what you need in this case. Do you understand that?
Yes, sir.
Do you really?
I do now.
Okay. Is there anything that you would tell me that you would, and I don't want you to tell me any facts of the case or anything of that nature. Is there anything that you would tell me that you're having a hard time understanding that we can talk with Mr. Schmidt about today?
Yes. I'm still going to Anderson to get help, but
Say that again. I can't hear
I'm
you.
going to Anderson to get help still. I just started some medication. It's doing better.
Good. And you've told Mr. Schmidt that, right?
In the past 2 weeks, I started taking it. So hopefully that's starting to calm everything down a bit.
Okay, good.
It's keeping me more focused.
Okay.
Stuff on track. Just all this stuff is coming out of left field from, cause I don't steal, and I never had a record of stealing people. And I believe in karma.
Understand. Mr. Schmidt, would you like to address anything that's been raised by Mr. Richardson or the court?
No, sir, I think that the court has explained many of the concepts that I've explained. And I think that, ultimately, if Mr. Richardson's comfortable with continued representation for me, I'm more than happy to continue to try. So it's up to the court.
Okay. So Mr. Richardson is already set on the trial docket, is that correct?
That's correct.
So Mr. Richardson, are you comfortable with Mr. Schmidt remaining as your attorney?
Yes, sir.
Do you have any more questions that the court can try to help you understand the best that I can?
Summed it up pretty good. I do appreciate that.
You're welcome. You're welcome. And you understand that communication is something that we all struggle with. We all struggle with, whether we're talking to our family members or our coworkers or just people in the public. So when you're trying to communicate with your attorney, you have to be understanding of what he's understanding you to say. Okay. And he's got to be understanding of what you're trying to say. All right. So you got to be patient. That's my point. You got to be patient in that communication. All right. So if you're not expressing it very well, you got to do a better job. And if someone else can help you express that, then talk to someone else, help get that, figured out and present it to Mr. Schmidt, and then let him try to explain things to you the best that he can. If you don't understand, tell him you don't understand and why you don't understand. Continue to do that. And then I think that will improve your relationship. And that relationship is just a working relationship. It's an attorney-client relationship. It's nothing more than that. You don't have to be his best friend. He doesn't have to be your best friend. He's here for a sole purpose of giving you legal representation that you can't afford because you're indigent. And I don't have just 100 attorneys standing by that I can say, okay, Mr. Schmidt and Mr. Richardson aren't communicating, so okay, I'm going to grab another one and give them to you. And because there's no guarantee that you're going to be able to communicate with anyone better than Mr. Schmidt has. There's no guarantee in that anyway. But two, I don't have that. I don't have that ability. I don't have that option. Okay. So you're going to have to put in the work and the effort to try to understand where you're at, whether you like to understand it or not, you have to understand it. Okay. Yes. Does that make sense? Okay. Anything else, Mr. Schmidt?
No, sir.
All right. Anything from the state?
No, thank you.
Okay. All right, then, court feels comfortable at this time, denying the motion to withdraw based on Mr. Richardson's, testimony and based on Mr. Schmidt's, statements to the court regarding continuing, representation. Of course, Mr. Schmidt, if any other issues reappear regarding this, matter, then obviously bring it to the court's attention. We can readdress it if necessary. Okay. And so he already has an appearance date set, correct?
That's good.
And is that probably next week?
I believe it's Monday, is that correct?
Monday, yeah, Monday. So Mr. Richardson, we'll see you back up here on Monday. Okay, downstairs, and you'll meet with my staff. You sure you don't have any other questions before we conclude today? Okay, then have him sign his notice of appearance today and just put Monday's date on it.
What is that date on Monday, the 22nd, correct?
22nd, yes. Sergeant Martinez, will you go call the names Joshua Moyers, William Ponder,
Don't go.
and Robert Wood? Thank you, Sergeant Martinez. For the record, cause number CR 25-185, State of Texas versus William Lee Ponder. His name, Mr. Ponder was set for appearance today on arraignment at 9 a.m. He has failed to appear. Court also notes that his bondsman, Easy Pickens Bail Bonds, has filed a 17-19 release of surety request. The court, having previously just taken that under consideration, the court will issue an order on bond insufficiency and request the arrest of Mr. Ponder for failure to appear. CR 18-136, State of Texas versus Joshua Lawrence Moyers. Mr. Moyers was ordered to be in court today for arraignment on assault of a family or household member, a third-degree felony. Court finds that Mr. Moyers has failed to appear. His name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias. Clause number CR 25-188, State of Texas versus Robert Dwayne Wheeler. Mr. Wheeler was ordered to be in court today for arraignment on a second-degree felony offense of robbery. The court finds that his name has been called loudly, distinctly 3 times in the courthouse with no response. The court will take the issuance of a judgment nisi under consideration. The court finds that counsel, Mr. Richard Smith, has asked the court to take that under advisement and give him an opportunity to contact Mr. Wheeler, citing the date of offense being April of 2022 and the indictment being returned in August of 2025. He believes that Mr. Wheeler's address that the court sent to is probably not a good address, and so he's asked for time to attempt to contact Mr. Wheeler. The court will take that under advisement until September 30th at noon. Mr. Wheeler does not make an appearance by that date, and the court will issue a judgment nisi and alias capias on his personal bond. All right, I believe that concludes the court's morning docket. So we'll stand in recess until 1:30 for the afternoon docket.